Hi, I'm attorney Jeremy Huss. When are the 3 times police can search a motor vehicle without a warrant? Generally, police need a warrant to search pursuant to the 4th Amendment. However, there are 3 exceptions to this warrant requirement when it comes to motor vehicles. Let's talk about the 3 of these exceptions. First, there is an automobile exception to the warrant requirement. This exception allows a warrantless search of a vehicle if law enforcement has established probable cause. The reasoning behind this automobile exception to the warrant requirement is that a vehicle is mobile by nature and is capable of imminently being placed into motion. Obtaining a warrant takes some time and may jeopardize a loss of evidence due to vehicle mobility. As such, it is well-established law that police may search a vehicle without a warrant if probable cause is present. Probable cause exists when law enforcement has reasonable belief a crime has been or is being committed. Here are some examples of what constitutes probable cause to search a vehicle. First, apparently illegal items in plain view for police to see from outside the vehicle. For the officer to see evidence in plain view, the officer must be in a legal location and not manipulating or moving items to see an object. Items in plain view could be any contraband, including weapons, drugs, drug paraphernalia, or large sums of cash. Seeing any of these items in plain view would give law enforcement probable cause to search a vehicle without a warrant. Also, probable cause to search a vehicle exists if law enforcement smells evidence such as alcohol, or if a canine is run on the outside of the vehicle and hits on the vehicle. Probable cause will also exist if a person admits to possessing illegal items in the vehicle, or there appears to be an officer safety issue, or there are reliable witness statements that describe the vehicle as being involved in a crime. Any of these scenarios or similar scenarios will provide probable cause for law enforcement to search a vehicle without a warrant under the automobile exception. The second way law enforcement may search a vehicle without a warrant is if a person with authority provides consent for the search. Police do not need reason to ask a person for consent to search and can really just ask to ask. But more importantly, a person has a right to refuse an officer's request to search. Law enforcement cannot coerce a person into consenting to a search. And unless the officer has probable cause or a warrant, they must respect a person's refusal to consent to a search. It is important to never grant law enforcement consent to search in any scenario, including consent to search the vehicle. Summing up to this point, 2 ways law enforcement may search a motor vehicle without a warrant. First, if probable cause exists. Second, if a person with authority consents to the search. And a third way law enforcement may search a vehicle without a warrant is after a person is arrested. A person could be contacted while driving and be arrested for DUI or for having a warrant where there is nothing else visibly illegal in the vehicle. Or a person could be arrested for criminal conduct outside their vehicle. In these scenarios, law enforcement may not have probable cause or consent to search the vehicle. But law enforcement may conduct a search incident to arrest, which would include anything within a person's wingspan. And if a person is in or close to the vehicle, the search range would include that. Also, after a person is arrested for DUI or for anything else while in or around their vehicle, law enforcement is going to tow that vehicle. Most law enforcement agencies have tow policies in place requiring an agency to tow a vehicle after an arrest is made. When this happens, law enforcement will conduct an inventory or administrative search of the vehicle. This search is completed to document the items in the towed vehicle in case of theft or loss accusations. But anything found in this search can be seized and taken as evidence against the driver or vehicle owner. Now, we just spoke about 3 ways the police can search a vehicle without a warrant. In some cases, the vehicle search and resulting property seizure is unlawful and violates the 4th Amendment. There could be issues with the reasons for the traffic stop and issues with law enforcement vantage point and ability to observe. It is important for any case involving a search without a warrant to be reviewed by an experienced criminal defense attorney. This is important because an unreasonable search issue must be properly framed in a pretrial motion to suppress. And if a judge finds law enforcement violated the Fourth Amendment, the court will suppress any evidence found during the unlawful search pursuant to the exclusionary rule. The exclusionary rule will prohibit the use of the evidence at trial. This does not require a dismissal, but the impact will often result in a dismissal of charges. Any person who has been stopped and had their vehicle searched by law enforcement without a warrant may have a Fourth Amendment issue or an unlawful search issue. As such, it is important to contact an experienced criminal defense attorney, like the attorneys at Huss Law. Call us today for a free consultation.